Okay, let's unpack this. Today, we're diving into a truly pivotal Supreme Court decision. Trump v. Sessa, Inc.
Right?
This case zeroes in on a fascinating and often contentious legal tool known as universal injunctions.
Mm-hmm.
Now, these aren't your typical court orders that just apply to the people directly involved in a lawsuit.
No, they're much broader.
Exactly.
Yeah.
A universal injunction issues a command that applies broadly to everyone who might be affected by a particular government action. It's a hot topic, sits right at the intersection of executive power and judicial oversight.
It really does.
And our mission today isn't really to get into the political weeds. Instead, we're pulling back the curtain on the incredibly compelling arguments from the justices who sharply disagreed with the court's main decision.
That's right. The court's majority ultimately sided with the government, effectively limiting the use of these universal injunctions.
Right.
But the dissenting opinions from Justice Sotomayor and Justice Jackson offer a really profound counter-narrative. What's particularly fascinating here is how they transform what might seem like, a technical legal debate
Very effective.
into a fundamental discussion about the very nature of judicial power, the limits of executive authority, and what it truly means for a government to be of laws, not of men.
That's a powerful phrase.
It is, and they connect deep historical legal principles directly to the practical, everyday implications for you, the individual citizen. And to truly grasp the weight of their defense, it helps to understand the majority's perspective briefly.
Good point.
Yeah.
What was their core concern?
Well, the majority, in essence, argued that universal injunctions represent an overreach of judicial power, potentially granting federal judges too much authority over executive branch actions and maybe upsetting the balance of power envisioned by the Constitution.
Okay.
Their concern was largely rooted in what they saw as a historical lack of precedent for such broad injunctions, especially in, early American legal practice.
That context is crucial. So with that in mind, let's set the stage for this specific case. The backdrop here is President Trump's Executive Order number 14160.
Mm-hmm.
This order attempts to redefine American citizenship, specifically for children born to mothers who are unlawfully present or temporarily present in the U.S., particularly when the father is not a U.S. citizen or lawful permanent resident.
Right, a very specific group.
Very specific. Justice Sotomayor, in her dissent, comes out swinging, arguing that this executive order is patently unconstitutional. What's the bedrock of such a strong claim for her? Where does she even begin to dismantle the executive order?
Well, she starts right with the text of the Constitution itself, specifically the 14th Amendment Citizenship Clause.
Okay, the text.
Yeah, it states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
All persons.
Exactly. Justice Sotomayor emphasizes that crucial phrase, all persons, arguing it means exactly what it says, without any discrimination based on parentage or the immigration status of the parents.
So no exceptions written in there for parent status.
None. To her, the meaning is crystal clear. Virtually everyone born within U.S. borders and subject to its laws is, by definition, a citizen.
So she's pointing to the plain language of the Constitution.
No.
But does she go beyond that? Does she bring in historical context to support her interpretation, perhaps showing this isn't some novel reading?
Oh, absolutely. She doesn't just rely on the text. She anchors her argument in centuries of legal tradition.
Okay.
She points to the long-standing English common law principle of jus soli,
Just solely.
which literally translates to right of the soil. This principle made birthplace, not parentage, the primary determinant of citizenship.
Right. Where you're born matters.
Precisely. She notes that this jus soli principle was brought to the U.S. from the very founding, deeply ingrained in our legal system, with influential figures like James Madison and Justice Story affirming it repeatedly.
So founding figures supported this idea.
Yes. And what's key here, in her view, is that the 14th Amendment wasn't some kind of legal innovation in this regard, but actually a powerful restoration and constitutional embodiment of jus soli.
A restoration. Interesting.
Yeah, she argues it was a direct legislative correction after the infamous Dred Scott v. Sanford decision,
Dred Scott.
which she calls a grievous error that wrongly denied citizenship to children of enslaved Black Americans by ruling they were not citizens.
So it was about rectifying a monumental historical injustice and codifying a long-held understanding.
Exactly. She then highlights how United States v. Wong Kim Ark in 1898 unequivocally confirmed this principle for children of Chinese immigrants.
Okay, another key case.
Right. That case, she explains, meticulously analyzed the subject to the jurisdiction clause, limiting it to very narrow, specific exceptions.
Like who?
Children of alien enemies during wartime, or diplomatic representatives from foreign governments, basically, those not fully subject to the U.S. legal system because of their specific status.
I see.
Later interpretations added Indian tribe members for similar reasons of distinct sovereignty. This understanding was further codified in the 1940 Nationality Act and, importantly, consistently recognized by the executive branch itself for decades.
The executive branch recognizes this too.
Yes. She even quotes from a 1995 Office of Legal Counsel opinion, which explicitly deemed any bill attempting to deny birthright citizenship based on parental status unquestionably unconstitutional.
Wow. Unquestionably unconstitutional.
That's the phrase. So for Justice Sotomayor, the unconstitutionality of this specific executive order isn't even a close call. It's settled law.
Given all of that historical and legal precedent, Justice Sotomayor argues that the government claiming irreparable harm from not being able to enforce this potentially unconstitutional order, well, it defies logic. She really challenges the idea that the executive is legitimately harmed by being prevented from, as she sees it, breaking the law. But isn't there an argument to be made that any delay in implementing an executive order, even if later overturned, could hinder legitimate government function? How does she counter that perspective?
That's a fair question, and she addresses it head-on. She views the majority's position as endorsing what she calls a radical proposition.
Okay.
The idea that the president is harmed whenever he can't do something he wants, even if that action is ultimately unlawful. She points out that if a court orders the government to simply do what it's already constitutionally required to do, there's no legitimate harm suffered by the government. In fact, she argues, adhering to the Constitution prevents harm.
Prevents harm, okay.
She emphasizes that the executive doesn't have a right to act unconstitutionally. Therefore, being stopped from doing so isn't a harm in the legal sense, but rather the upholding of the law.
And she backs up her argument for broad judicial relief for universal injunctions by looking at the very roots of equity in law.
Yes. She argues that equity's history, going all the way back to English bills of peace, which were, essentially legal mechanisms for courts to resolve a single issue for many people at once, preventing endless individual lawsuits.
Right, stopping a flood of lawsuits.
Exactly. That history allowed courts to settle disputes affecting whole communities and prevent a multiplicity of suits. She cites federal courts using universal injunctions for more than a century in landmark cases.
Which ones?
For example, she mentions Lewis Publishing Company v. Morgan, a 1913 case about postal rates, Pierce v. Society of Sisters from 1925, protecting parental rights in private schools, and West Virginia B.D. of Ed v. Barnett from 1943.
The flag salute case.
That's the one, famously protecting the right not to salute the flag. All of these provided broad relief beyond just the named plaintiffs.
So there is historical precedent for broad relief.
She argues there is, and that the historical absence of universal injunctions before the late 20th century wasn't due to a lack of inherent equitable power, but rather due to other things, other constitutional and procedural limitations.
Like what?
Like sovereign immunity, which protects governments from lawsuits, and restrictive venue rules, which dictated where a case could even be filed.
Practical barriers.
Exactly. When those barriers were gradually removed and federal laws expanded, universal injunctions naturally arose as an adaptation of equity to the complexities of modern governance.
So what does this all mean for you, the listener? Why should you care about whether an injunction is universal or merely party-specific? Sounds like a pretty technical distinction, but Sotomayor makes it sound incredibly vital.
Because Sotomayor argues that universal injunctions are absolutely vital for protecting foundational constitutional rights, especially in a case like this one.
Okay.
She paints a very stark picture of the consequences: exceptional, irreparable harm to newborns who, under this executive order, would lose their citizenship.
Lose their citizenship.
Yeah, impacting their access to critical public services like SNAP and Medicaid, and potentially facing statelessness or even deportation. She describes it as chaos for families and a potential administrative nightmare.
A nightmare, definitely.
And for states that brought suit, she explains that only a universal injunction could provide complete relief, because children and families move across state lines.
Of course, yeah.
So a patchwork injunction, where the order only applies to the specific individuals who sued or within specific jurisdictions, would make it utterly unworkable for states to administer benefits and verify citizenship status consistently.
You'd have different rules depending on where someone moves.
Exactly. This isn't just legal theory, it's about tangible effects on real people, ensuring that a constitutional right meant to apply to everyone actually does apply to everyone equally.
And there's a truly stark nugget in her dissent that speaks to a surprising stance from the government regarding its own obligations, even to the Supreme Court.
Yes, she highlights a moment during oral argument. This is really something. Where the Solicitor General, that's the government's chief lawyer representing it before the Supreme Court, explicitly refused to commit to obeying any Court of Appeals order holding the citizenship order unlawful, even within that circuit, if it wasn't a party-specific injunction.
Wait, refused to commit to following a Court of Appeals ruling?
If it wasn't party-specific, yes. She argues this creates an incredibly dangerous precedent, implying the government might not even treat Supreme Court opinions as de facto universal injunctions without an express, explicit order covering everyone.
That's startling.
It is, and it raises an important question for you, the citizen. If the government isn't compelled to act lawfully unless specifically enjoined for every single person, what does that mean for the general population and the integrity of the law?
Yeah, does it mean the executive can simply choose to ignore court rulings for those who haven't directly sued?
That seems to be the implication she's drawing.
That implication from the Solicitor General's stance is indeed unsettling. And Justice Jackson, joining Sotomayor's dissent, takes this line of thinking even further, doesn't she? How does she frame the stakes here?
Oh, she frames it as an existential threat to the rule of law.
Existential threat. Strong words.
Very. She cuts through the legal jargon, saying this isn't just a mind-numbingly technical query, but a fundamental, even alarming question. May a federal court in the United States of America order the executive to follow the law?
Wow. Puts it very plainly.
Yeah, this is her core insight. Limiting universal injunctions isn't just a procedural tweak. It's tantamount to the court giving the executive explicit permission to act unlawfully unless each violation is individually litigated. It turns a foundational right into an unearned spoil that must be fought for.
She views the executive's request to limit universal injunctions as basically a request for this court's permission to engage in unlawful behavior.
Exactly. She grounds her dissent firmly in the founder's intent, emphasizing that the Constitution was meticulously designed to limit power and prevent tyranny.
Checks and balances.
Right. The judiciary, she argues, is the essential check in this system, making sure everyone, including the executive, to follow the law full stop. In her view, the majority's focus on historical English courts is too narrow for our unique constitutional system, which demands that courts uphold the law universally, not just for a select few.
So her argument is that if courts can't issue universal injunctions, the government can essentially pick and choose who it applies the law to. It sounds almost like a dual legal system.
Precisely. She vividly describes what she calls a dual-track system.
Dual track.
One where the law reigns for the individual plaintiffs who have the means and opportunity to sue, and a second zone where all bets are off for those who lack the resources, awareness, or ability to go to court.
A zone of lawlessness.
That's her phrase. In this zone of lawlessness, the executive's actions are left to its prerogatives, meaning compliance with lower court rulings on constitutional matters becomes optional without a personal injunction.
So obeying the Constitution becomes optional for some people.
That's the danger she sees. This, she argues, fundamentally undermines the very principle of a government of laws and not of men. It creates an incentive for the executive to continue unlawful conduct until each person harmed individually obtains an injunction.
This raises an important question for us all. Who would be most affected by this zone of lawlessness, and why does Justice Jackson emphasize this?
Well, Justice Jackson warns it would disproportionately impact the poor, the uncounseled, the under-resourced, and the unwary.
Those least able to fight back in court.
Exactly. She argues that constitutional rights, like birthright citizenship, are pre-existing rights guaranteed to all citizens from the start. They are not unearned spoils that must be individually litigated for, as if you have to win them back from the government.
Right, they're inherent.
Yes. A universal injunction, in her view, simply restores what the people were always owed, because the very concept of constitutional rights means the people are intended beneficiaries of the constraints the Constitution imposes on executive action.
So the injunction just enforces the existing right for everyone.
That's her point. Without a universal injunction, the executive is allowed to continue violating rights for everyone except the specific individuals who sued and won.
She uses a really vivid hypothetical to drive this point home, right? To make it undeniably clear how this dual-track system would play out in real life.
Yes, she imagines a hypothetical that truly brings the implications into sharp focus. A blatantly unconstitutional executive order to summarily incarcerate political foes.
Okay, pretty extreme example.
But it makes the point. Under the majority's ruling, an injunction would only protect the named plaintiff who sued to stop their own imprisonment.
Just the one person.
Right. This would leave the executive free to continue rounding up others despite the order already being deemed unlawful by a court.
Even though a court said it's unconstitutional.
Yes. She concludes that this situation would essentially require judges to look the other way at ongoing executive lawlessness, directly contradicting their oaths to uphold the Constitution.
Forcing judges to ignore the law.
For her, forcing courts to acquiesce to executive lawlessness is a grave blow to judicial independence and the rule of law. It undermines the very structure of checks and balances.
What's fascinating here is that both dissents acknowledge that class actions under Rule 23 could still provide broad relief, but they also highlight the significant hurdles involved in that process as a practical alternative.
They absolutely do. Sotomayor details the drawn-out procedural bog of class certification.
Yeah, class actions aren't easy.
No, she explains the immense expense, the delays, and the heightened evidentiary standards required to get a group certified as a class. It's not a quick fix at all.
Right.
And Jackson points out that even if class actions can achieve a similar effect in some cases, it fundamentally doesn't resolve the core problem. The executive having discretion to disregard the law for non-litigants.
It doesn't fix the zone of lawlessness issue.
Exactly. She argues this decision allows executive lawlessness to flourish, effectively creating what she calls a perverse burden shifting.
Burden shifting meaning?
Instead of the government being inherently bound by constitutional rights, individuals must proactively secure their pre-existing rights through complex, resource-intensive litigation. It shifts the burden of upholding the Constitution from the government onto the individual citizen.
Okay, I see. That's a heavy burden for individuals.
It really is.
So, what does this all mean for us, the listeners, as we think about the future of our legal system and how power is exercised in our country? This deep dive into these dissenting opinions reveals a profound disagreement at the very heart of our legal system. Is the court's primary role just to resolve disputes strictly between named parties? Or is it to ensure universal adherence to the Constitution and the rule of law for everyone?
And Justice Jackson's words serve as a stark warning, particularly resonant on considering the slow erosion of foundational principles. The accretion of dangerous power does not come in a day.
A slow creep of power.
Yeah. She fears that by limiting the judiciary's power to issue universal injunctions, the court effectively allows the executive to choose law-free action, ultimately risking the downfall of our governing institutions.
Powerful stuff.
She believes that the majority's decision fundamentally misses the plot, ignoring the wisdom that men have discovered no technique for long preserving free government except that the executive be under the law.
The executive must be under the law.
That's the core idea. If the executive can simply ignore court rulings for those who haven't sued, what does that leave for the vast majority of citizens?
It's a truly thought-provoking challenge to consider. How do we balance the need for judicial checks on power with legitimate concerns about judicial overreach, especially when the Constitution's promises are at stake for every single individual? What stands out to you from this discussion about the very nature of our government and the rule of law? It's definitely a question worth mulling over long after our deep